Good evening. This is Rahul Reddy. Every week we do bring in immigration updates, and we also take live questions. Emily, what do we have today to discuss?
Yeah, this week we want to talk about employment-based I-485s. We are seeing more scrutiny on those than we ever have before. So we'll talk about what kinds of questions are being raised, what to be prepared with, and where the scrutiny is coming from. And the lottery for H1B, the deadline is next week, March 19th. So the lottery window is open. Registrations can be done now. What are some of the last-minute registration makes that can cost you in the lottery and beyond? We'll also talk about the H1B to B2 change of status. We've been talking for a number of weeks about new types of RFEs. We've been seeing new questions about changing status back to H1B with a pending B2. So we'll give you updates on where we stand there. And lastly, we'll talk about the one travel mistake that has just destroyed thousands of H1B careers and how you can make sure that you avoid that same mistake.
First of all, let's discuss about the 485 applications that have been pending for the employment base for a lot of years. And if the priority date is current, we just definitely want you to act to get your case adjudicated. Otherwise, you guys know that it may go backward and forward, backward and forward. So if you are eligible for, we strongly recommend if your application is pending for more than 1 year, and if your final action date is current, you should go for writ of mandamus, and that is the best way of getting your case adjudicated. Now, coming into some of the interpretations of the USCIS, there are more stricter interpretations of there. We always told that if you're in a similar profession, you should be fine, but we have seen one or two denials, not to a great extent to be fearful about, but we have seen some denials. There was an RFE with regards to what position that person was being held, and the job advertisement, the labor certification, what was the job duties and what are the job duties currently. Now, labor certification generally, lawyers keep generic job duties. And specifically, these labor certifications were designed more than 10 years ago. I think most of the softwares are no longer relevant at all. We said if you work on a software field, you should be fine. But we saw a denial or two, Emily. Can you comment more? Should people should be more concerned about it, or it is one of a case?
I think that is hopefully just a one-off case where it stems from the interview and things that just kind of get lost in translation and aren't conveyed properly during that process. It tends to lead things down a path where they're asking a lot of additional questions that really just created a lot of confusion. People need to be aware that the green card process is based on ultimately the job offer for the position you'll take when you get your green card. It may be different than the job that you're in now or the job even that you held at the time the labor certification was filed, but you need to be moving into that job when you receive your green card, unless you used AC-21 to move to a different employer or into a different position. And so when an officer asks, what is your current role? If you're not in the same role that you were sponsored for, you need to make sure you specify that. I'm currently doing X, but my employer has offered me Y position, and I do intend to take up that position as soon as my green card is approved. You can cut out a lot of the confusion just by being more clear when you answer those questions and following up with, if you're not clear on, if you're not understanding what the officer is getting at, what time period they're talking about, which job they're talking about, it's okay to ask for clarification on that before you answer so that you don't mistakenly answer in a way that makes it sound like something's wrong when everything is actually fine.
There is also a 245K where a person can be out of status for less than 6 months and then still get the green card in the employment-based immigration. According to the new field memo of the USCIS, that status violation they should only consider from the last entry into United States. So if there are any status violations, for example, if at one point of time, if a person was not getting paid according to LCA, but later on he left the country and came back, and from that time things were doing fine, they should not consider the status violation that was done previous to the last entry. That means that, let's say, for example, the person entered the United States in 2019 and he filed the adjustment of status in 2020. If there is any status violation in 2016, any LCA violation where the person might have worked at a different location or might have got a little bit lesser paid than LCA wages, should not have affected the 485 application. Is there any change in that, Emily? Or is it only one of a case if there is any changes, or is it a change in the policy entirely?
Yeah, so we did hear from another attorney about a denial in that kind of scenario where they were talking about 245K and violations that occurred prior to the previous entry. I think that, looking at the policy manual, it does appear that it was updated in February 2026. At the very bottom of the screen, it has the last update date. But those particular sections that talk about, only looking from the last entry going forward are still there. So I don't think they've changed the policy manual. I think they're still following the Neufeld memo. I hope this is just again one of those one-off cases where it's based on the facts of that particular case, or maybe just an officer that was not aware of how 245K actually works. Hopefully, but the hard thing with all of these is when they're one-off cases, they still impact people, and it can be very difficult to overcome those. You have to jump through a lot of hoops, even when you're right. So that's kind of the difficult thing when we see bad decisions, improper decisions, is it really impacts your ability to continue to work and stay in the US and travel and all of those things.
Overall, we would say that definitely the 485 interpretations have been a little bit tougher than what it was. However, we see a lot of cases getting adjudicated, though. We see some fast adjudications of the employment-based cases, especially if they are filed, if the priority dates are current. I'm speaking about the cases that were filed in probably August to about January. These August of 2025 to January, they're getting approved. Now, we have cases that are filed in 2020, 21 that are still pending, even though final action date is current, because the officers are sleeping on those applications. Based on our daily conference call that we get it, the 48,000 subscribers in the YouTube that we have, and Facebook and Twitter, we get a lot of information from the people. One, we get it from our clients. We're practitioners. We do have a big law firm, and then we do practice. But at the same time, we do get a lot of information from other sources. We definitely want people, if the priority date is current, to act on it as soon as possible. At the same time, be cautious. If there is an RFE, if there is an interview, we definitely want you to answer it by a lawyer, unless it's just a medical RFE, which is just respond to the medical RFE. But otherwise, definitely have it answered by an immigration lawyer. And if you are going to the interview, though, you may want to consider to do a mock interview for the 485 application, to go over the entire application, to make sure everything is all right. And if there is any fault, then it's better to correct it rather than discuss with the immigration official. Anything else, Emily, before we go to the next topic?
No, so on the lottery, what are some of the potential mistakes people could be making right now as we're, already about a week in, only a week to go, that could really impact them in the future and not, make their H1B problematic?
Emily, one thing that I see, because I roam around in the Indian community, there are some fraudulent companies. People will approach these fraudulent companies to file the H1B when there's no real job. I definitely recommend people to stay away from these companies. If they don't have a job, if they're applying for the job, be not. I would definitely say no to it, though. And if you still want to, I would still say to consult an immigration lawyer to vet out how this company is telling that they have a job when you're actually not working for that company, though. Now, there are exceptions available. Let's say, for example, if Google comes and Apple comes and then they will approach that you have a job that they're willing to file H1B, I'm fine with it. Now, if it's a small consulting company that is in New Jersey or Dallas, and this consulting company has, no jobs at all, and they're filing for 100 different people for you, and they're filing an H1B in the lottery system, even if the job is not there, we definitely recommend that you stay away from these companies. Do not do anything. You cannot pay the money for the company to file the H1B. You cannot pay the company to enter into the lottery. And if you don't have a job, please don't. Because here is the problem, though. By colluding, by cooperating with a person who's doing fraudulent activity, you may be barred forever to come into United States. And if you want to, please go ahead and search for the company called Integra Solution Aztec companies. These are the companies that solicited people to get them into the OPT and STEM extensions, and they collected the money. Thousands of their lives were being destroyed because of that. And now there are a lot of consulting companies that also do that, that affects the lives of the people. So do not file H1B if you don't have a job, because this will affect you in the lifelong. You can continue going to school for a couple of more years, or probably go to India and come back at a later days when things are all right, but definitely not file H1B with a fraudulent company.
Yeah, and
Also,
I would also, oh, sorry, go ahead.
you go ahead, Emily.
Yeah, I was also going to say, obviously there's room for, um, trying to increase your chances in the lottery based on selecting certain SOC codes or the work location being in a certain place. So if you are considering moving to a new work location where you can work remotely, where there's a lower prevailing wage that might allow you to have a higher number of chances in the lottery, you know, that is a risk, because if you later move away from that location and have to file an amendment, they're likely going to question what was your intention at the time of the lottery, and were you just trying to game the system? So it needs to be actual need for you to work in that new location. It can't just be for the purpose of the lottery. And the same goes for salaries. Now, it's one thing if you're looking at, as a company, prevailing wages and realizing that a person's salary is just $500 away from the next wage level, and you're considering increasing the salary to give them an extra chance. I think that's perfectly acceptable. But if you're talking about, you're currently being paid a level 1 wage, or you're not working with that company at all, and they're saying they're going to file for you a level 4 wage when the job itself is only a level 1 or level 2, I think that's something to be careful of as well.
Emily, we have advised a lot of people that, hey, if you lose the job, you can move to B2. USCIS has put it in website that you can move into B2, and even when the B2 is pending, you can change the status to H1B. Now we are telling otherwise, that no, don't move to B2. It may be very dangerous. Can you explain what's going on it, and what is going on currently? We have a lot of heat coming up on it. People inquiring about it. We have made some people file the B2 applications, and there is notice of intent to deny for some of the B2s. There are RFVs on the H1B saying, "Hey, your B2 is still pending." What is going on it?
Yeah, so without any kind of public announcement, it's very clear that USCIS has changed its policy on saying that searching for jobs is a permissible B2 activity. They're saying very clearly it's not. And they're also changing their policy about being able to file a change of status back to H1B or back to a working visa while your B2 is pending, even though their website said for several years that yes, you can do that, and yes, we'll approve the H1B and we'll approve the B2 at the same time. Now all of a sudden they're saying, wait a second, we see you filed an H1B. That tells us that you plan to stay in the US indefinitely. Therefore, you don't qualify for the B2. And so they're sending RFEs on the H1B saying, number one, we need the B2 approval before we'll approve the H1B. And then on the B2 saying, wait, you filed an H1B, prove to us that you still intend to depart at the end of your B2 stay. And so you're really put in a catch-22 situation where, in my mind, it's become quite clear that their whole goal, the goal of USCIS with their new director, is to get as many H1B workers outside the country as possible. They're wanting to deny the B2, which then means the change of status to H1B portion is going to be denied. They'll still approve the petition, but it'll be for consular processing. Guess what happens when you're consular processing an H1B that was filed after September 2025? The $100,000 fee kicks in. You have to leave the country because you don't have B2 status, you don't have H1B status. Once you're out of the country, no company is going to sponsor you for an H1B while this $100,000 fee is in place. Guess what? They win. They've gotten people out of the country with no way to get back. That is their goal with this. Now, in terms of what we're seeing right now in our office today, myself and one of my colleagues, we both responded to similar RFEs almost identically. He got his approved, I got mine denied. So we're 50-50 right now. And the only and we have one other case that did get denied that our office handled. So we are 1 for 3 at this moment. And we've made a lot of arguments in these. They were very well written. It's just, it doesn't matter what you submit. They are saying that what you are wanting to do is not permissible, even though yesterday it was permissible. They don't go into any analysis about the documents that you've submitted. It's purely based on, you know, the purpose for your B2 stay to file another petition or to look for jobs is no longer possible. The only difference I can tell between my case that got denied and his case that got approved was my case had already filed a change of status back to H1B, which was pending. And in his case, he had not filed anything else. So I don't know if that's the difference, or it's just different officers, or maybe the other officer didn't get the memo about them not following the memo. I don't know what it is, but it's very clear that they are no longer going to be allowing this. So if you're in a job loss situation right now nearing the end of your 60 days, I would not suggest change of status to B2 if you are eventually wanting to be able to switch back to H1B while you stay in the US.
And if there is an RFE or NOI, a notice of intent to deny, we strongly recommend that you do it with a lawyer. Don't respond it by yourself. And the lawyer she is speaking about who got the approval is Philippi from our office. He's a very good lawyer, but you know, he's smart. I guess we don't know, but definitely we don't recommend you filing by yourself. If you're already in B2, if you got an RFE or a notice of intent to deny. Emily has written a very good article on it, and our office has been going through a lot of discussions between me, Stephen, Rebecca, Emily, and a lot of other teams and our members who have been banging our heads on these things to come to a very good conclusion. But yeah, we are improving in our arguments, but yeah, we just want to inform that it is not, it's a tricky situation right now, as Emily pointed out. Please read the blog at rnlawgroup.com. Emily has written a very good blog on it. And you go to blog and you can read that on that particular topic. And at this point of time, we do suggest that if you got laid off, though, we are suggesting, obviously, if you have an H4 options, always, anytime, we always suggested H4 options, never suggested B2. But if you don't have an H4 option, though, probably F1 should be the best option for you to move on. Even if you have done a master's degree, you can still consider doing one more education before you leave the country. Anything else, Emily?
All right, last up, travel mistakes that have destroyed thousands of H1B careers. What is the big mistake?
Just travel outside the country. That's the big mistake I see. Also, Emily, what we have noticed is that we do have a daily Zoom call, and we do answer approximately around 25 to 30% people every single day. We are doing it from past 14 years, and I do that every day unless I'm on leave or something. Here is what I noticed, Emily. There are a lot of layoffs right now, and I see a good number of layoffs are coming off when people take a long leave of absence. I'm speaking about a month or so, especially when they're traveling outside the country, though. They come back. What is happening is that either because of the artificial intelligence or because of the pressure that Trump is imposing to not to hire the H1B, they are losing the jobs. That's one thing that even if you have H1B stamping, even if you have a good job, why not keep it though? Why deal with us? Don't deal with us. It's not good. Just keep the job. Don't travel. We have had situations where people are traveled outside the country. They have a H1B. They have some arrest record or something like that. Even though they are innocent, later on proved to be innocent, their visa got revoked. Their criminal case got completely dismissed, but their visa got revoked. Now they cannot come back. As you know, that their stampings are not available right now. We don't know even if they will get the stamping, because what's the purpose for them to revoke the H1B? Because this particular arrest happened probably in 2013, and they disclosed the information before. They got several times stamping. Now the Trump administration has revoked it, and they are stuck there. Also, whenever you are trying to come into the country, even though you have a visa, it doesn't guarantee for you to enter into United States. Every time you come into the country, then you will be inspected at the port of entry. They have to approve your entry to make sure everything is all right. If there is any deficiencies, or the officer is confused about any law or any regulations or any interpretation of the H1B, then you are out. I mean, you need to understand that when you are entering into the country, does you think so that the CBP officer knows everything about the H1Bs? You are absolutely wrong. Do you know how many non-immigrant visas are there, guys? A, B, C, D, E, F, G, H, I, J, L, M, N, O, P, Q, R. There is no S's, right, Emily? No, there's no S. No.
No.
T, U. I mean, the end, there is A1, A2, B1, B2, C1, C2, C3, D1, D2. I mean, there are several different categories. Within the H1 category, guys, you'll be very surprised. There is H1B, H1B1, H2, and there is H3. And of course, H4 is a dependent visa. I'm speaking of H1, H1B1, H2, H3. These are all either work visas or training visas within the H1Bs. If they don't understand something, they get confused one thing. Right now, the instructions from the Trump administration is just don't allow the people if you don't understand the things. They are not going to make an effort to understand the things. So that is where we see a lot of things going on in the airports at this point of time. Now, previously, the administrations were different. Yeah, if you have something very clear that this guy should not come into the country, they used to deny the entry. But that's not how this administration is doing. If you have any doubt, that guy should not come back. If you don't understand, that guy should not come back. They have clear instructions, and we suggest you do not travel at this point of time. And if you travel, I mean, first of all, don't. If you do, make sure that you have clear documentation. There are certain airports to be avoided and all those things. And now we have the Iran war. Who knows? You go there, you get stuck there. And you get stuck there, you lose the job. And you lose the job, you cannot come into the country. That's another thing. If you have a H1B, the whole purpose for you to come into the country is to do the job. If you don't have the job, you're not supposed to come back into the country. So my sincere advice to people is that please do not travel outside the country. Please, please, and please do not travel outside the country.
Yeah. And remember, if you do get stuck outside the country and you lose your job, the next company to apply for you has to pay the $100,000 fee. So again, all of this is designed to reduce the number of H-1B workers that are in the US. It is on purpose. That's why they're increasing administrative processing for visa stamping, delaying the case long enough till you lose your job, and then there's no way to come back while the $100,000 fee is there.
Here's one other thing that I want you to notice it. The administration has more rights when you go outside the country than when compared to when you're inside the country. For example, F1 visas have been revoked. Civis was been terminated for any people who have any arrest record, even though they're innocent proven later on though. What happened when we fought in the court was that we were able to get the service reinstated, but not the visa revocation. So the government is setting up traps and traps and traps whenever you cross the border. And if you escape all the traps, then you can come in. But why do that? Why? Please. Let's go to questions, Emily.
All right. So Sandy from YouTube says, for people with a prudential visa revocation, is it safe to travel to Mexico and use AVR, automatic visa revalidation, and enter back to the US? What if they've since received a new H1 approval and have a new I-94? Absolutely not. No, if your visa is revoked, it's as if you don't have a visa. So there's no visa to automatically revalidate. Automatic visa revalidation means it takes an old expired visa or a visa in an old category and automatically revalidates it, makes it valid the moment you're entering into the US. If you don't have a visa because yours has been revoked, there's nothing to automatically revalidate. So no, you definitely should not travel.
Yeah, that concept of going to Mexico and Canada when you're with the I-94, when the I-94 I-797 validity does not apply if your visa has been revoked or if you have any arrest records, does not apply. You should not go outside the country if you have visa revoked. Absolutely, you should not.
Vijay says, I'm working full time. My H1B extension is ending January 2027. My employer is not filing the I-140. My wife recently got the H1B in October. What are my options? Well, you could change to H4 and H4 EAD, and whatever company you're working for at that time can sponsor you for the labor certification or I-140, so that later you could change back to H1B and get extensions beyond the 6-year limit. You could look for other companies who are sponsoring you. You could potentially self-sponsor EB2 NIW or EB1A Extraordinary Ability, change status to F1, exit the country. Those are pretty much your options, unless there's some other category that you can qualify for.
Subra Patim Bhattacharya has this question. Emily, I may need your attention on this one too. He's asking, what should he answer when the H1B holder was in India? He has a visa stamping. When he comes back, he got paid in US dollar because in the vacation time he either worked or probably they paid for the vacation. Either of those things. This is stemming from a rumor that came from the port of entry of Abu Dhabi, where it is rumored, which I will offer a free consultation for the person who got deported in this particular sense, is that where the person worked in India illegally and he got paid in US dollar and they deported because of that. I feel very surprised. I don't think so that happened. And if ever that happened, it's definitely a mistake of the officer there. Remember, I was telling you before, if the officer does not understand, you're out. But in general, an Indian citizen can work in India. Absolutely not a problem. They don't even come under the H1B regulations. You want to, you go to Gurgaon, you go to Hinjwade in Pune, you go to Gachibowli in Hyderabad. I see a lot of ladies and men working in the midnight. They're all working in USA. They don't come to immigration lawyers like us. They don't need an immigration. So definitely that's not an issue. Getting paid in US dollars in US thing, that's something that the IRS of India might should have a problem. The IRS of US doesn't have a problem. They're taking the money. So definitely you should answer the question that you got paid in US dollars, nothing wrong with it. It's definitely either did not happen or it must be a clear mistake by the officer. So if people are traveling outside the country and they're coming back and they have a paycheck that is coming in, I don't see any problem. Now, we told people from the beginning, avoid Abu Dhabi airport. Anyway, Abu Dhabi airport is closed right now. You're not coming back anyway. But yeah, definitely, it's not a problem that if you get paid in US dollars. Do you agree, Emily? Or you have an issue?
Yeah, totally agree.
Have you seen any
No,
cases? We have about
no.
50,000 subscribers in the almost 50,000 subscribers here, Twitter, Facebook, and daily conference call. No. Have you seen any people?
Nope, not one. And I know they claim that, oh, it was because my Indian address wasn't on the LCA. Well, number one, the LCA is not needed when you're in India because you're not in H1B status. So the LCA regulations don't apply. And of course, there's no way to put an Indian address on an LCA. And I never would and never have, and have had plenty of people work from their home country remotely while they're in their home country. Never had an issue. So something more is going on there, or it's a fake story.
Also assume that if one of the guy had some criminal history of drug offense and then he got deported, what is he going to tell everybody? That he's going to tell, I got a drug offense, I got thrown out? No, he's going to blame something wrong on the immigration. So please take it with a pinch of salt, guys.
Um, Elon fan from X says, my priority date is December 2018 and my kid is 17 years old. How do I avoid him aging out? Um, I don't know. I'm assuming you're an EB2 or EB3. So really your only options are EB5 or EB1, where your date will become current or is already current. Um, Unfortunately, unless the dates miraculously move forward enough to allow you to file within the next couple of years here.
Um, 1 second.
DKJ232 from YouTube says, what's the current processing time for AOS that's current this month, filed in December 2025? I had one that I filed in January 2026 based on an approved I-140, got the approval notice today. So they're pretty quick. Now that, of course, is not across the board. I think normal processing time for employment-based 485s is listed as 19.5 months, which obviously is not accurate, but they can take that long if there's something weird going on in the case or they need to do an interview or something like that. So it's anywhere in between 3 months and 2 years, is my best guess there.
I recently got my green card in EB2. When am I eligible to file the US citizenship? Obviously, you know that 5 year mark is the time when once you get a green card, 5 year is the time that you're eligible for. However, you can file the citizenship application within the span of 90 days. It's not 91 days, but within the span of 90 days. So between 85 days or 80 days, that is when 5 year mark. So if you got the, let's say you got the green card on March 1st of 2026. So it will be March 1st of 2031. That's when the 5 year mark is. So 85 days before that is when you can file the online application for the N400 application. The good part of the citizenship application is that it's not that complicated, guys. A lot of people file the citizenship application by themselves. We are okay with it. If would I say that file your own green card? Obviously, we don't say that. But when it comes to citizenship, you can file it online too. A lot of people are asking questions. Hey, have they made it more stricter? They made the exam a little bit more stricter, but most of our clients who get the green card through employment based should not have much trouble. Their finances are very good. Their employment history is very good, and also their English is very good too. So all these things they made a little bit more stricter scrutiny, but mostly we haven't find any problems for the normal people who got the green card through employment based. We don't see any problem for them getting the citizenship.
Earthland's Tales says, I'm reaching the end of my 6 years for H1. Can we apply for the H4 and H4 EAD as a future start date? Well, you can apply that way. The real question is, will they give it to you that way? And that answer is generally no. They do not care what date you list on your I-539 application. They'll put it whatever date they feel like on that, as well as the EAD application. And right now, the EADs are needing the biometrics appointment for your photograph. And so you might end up in a situation where they approve your H4 and your EAD takes longer because of the biometrics. So you might be in a situation where you can't work for a period, and there's just no way to avoid that. You can try requesting a future start date on the I-539, but it's so hard to time that it's practically no way to actually ensure that it happens.
Maximus from Twitter has this question. Can you apply for the adjustment of status if the consular application was initially chosen for the application? Absolutely, you can. When the I-140 application, I'm assuming it's an I-140 application, has been chosen for the consular processing. If you are in USA and if you're eligible for the adjustment of status, can you just use the same I-140 to file the 485? Absolutely, you can. No problem with it at all.
Adibam says on TN, Canadian citizen applied for adjustment of status. If I leave and re-enter without the EAD, but with the AP, will I need to wait for the EAD to work? Yes. So when you are TN, you cannot leave without AP. And when you re-enter on AP, you don't resume your TN status. So you would need to have an EAD to work if you left while you were in TN status and returned on AP.
Is it safe to travel on green card these days? I have to make frequent short trips abroad to work and personal purposes. We don't see any problem in people traveling on the green card, though. As long as your travel is within 180 days and you're coming back and you're telling it's a short trip, I'm assuming it'll be less than 2 or 3 months. So if that is the case, though, I don't see any problem whatsoever at all in you traveling on a green card. No problem with it.
Sai says, my mother is currently here on a visitor visa, but due to the war, we need to extend her stay past the initial 6 months. What are the steps? Well, before her current I-94 expires, she needs to file an I-539 to request a B2 extension. It can be filed online through a My USCIS account, pay that filing fee, upload the necessary documents. The maximum time she can request is 180 days, and then wait for the receipt notice that will prove that she is lawfully present in the country, and wait for the decision to be reached on that. If no decision is made within those 6 months, she will need to depart, and that could have an impact on her B2 visa that's stamped in her passport. So you just need to make sure you understand all of that before you file that renewal.
Maximum has this follow-up question. Is the Child Service Protection Act, is it until the child becomes 21 or is it until 18? The answer is it is 21 years age, not 18. The child should be under 21. And of course, the child should not be married. If they're married, they could get kicked out of the application.
Srinath says, my wife filed an H4 extension in August 2025 and still waiting for the approval. Is there any process to expedite it? My H1 was approved 3 months ago. No, not unless it's outside the normal processing time, which probably it isn't at this point. And there's really nothing wrong in this situation. She is lawfully allowed to stay in the country the entire time that H4 is pending. Now, of course, if she's not able to renew her driver's license, that could be a problem. But no, there's no way to expedite it. They're not approving H4s in an expedited manner. So it's just doing the regular service request, otherwise litigation if you wanted to go that far, but that may not be necessary for an H4.
One of my friends' priority date is May 2014. Can he change the job now? He has an EAD from last 4 years. This comes from Vikas. We don't see any problem in changing the jobs as long as the job is in the similar occupation. Um, Even though we may have pointed out that one of the case got denied, that was not because of the change of job. Anyway, the one particular case was he was doing the same company job. But here, when people change the jobs on the adjustment of status after they are in EAD, the risk is very minimal, guys, at this point of time. And if not at all. I mean, never. So if I were the person, if I get a better offer, I'm going to move to a different job.
Jolly Mail says, join company A with the H1B receipt notice. Is it safe to transfer to company B before the approval of company A, but after the H1B grace period? Not really, because when you file the transfer to company B, USCIS could send an RFE saying they need to see the approval from company A before they'll approve company B. If you are then with company B and company A no longer needs that H1B, they may have withdrawn already, or if they get an RFE, maybe they won't want to respond. And then you end up with a denial of company B. That's going to cause a denial of the I-94 on company B. Therefore, the $100,000 fee is going to kick in. So you'd be much better off upgrading company A to premium processing, getting it approved, and then transferring.
A lot of people have question. Maria has this question. Uh, Jujur has this question. A couple of other people has this question. Sujit has this question. When would the priority date move? There are some extra numbers we're expecting because of the stricter interpretation of the law, because of the country bans where they are not getting the green cards for a certain country, especially in the consular processing. And even if they're in the country, they're not getting adjudicated if they belong to certain countries. So definitely we're expecting some numbers to be flowing into from the family-based into the employment-based. Now, that's what happened in October of 2020, where we saw a dates movement of 3 to 5 years at that point, 3 to 4 years at that point of time. Are we expecting the same amount of green cards that we've been wasted in 2020 and 2021 this time so that they fall into the employment base? Definitely not. But we are expecting some numbers, good numbers, more than 25,000, probably less than 60,000 green cards. We are expecting to fall into the lap of the employment-based immigration. So we may expect some movement, but will there be? If so, at what level it will be, we cannot judge it properly at this point of time. But you can see it in October of 2026. Then you will see in September, you'll get a visa bulletin for October. You can see it. Um, yeah, I mean, if you are planning to change the jobs, probably I would wait until October to see how the things will turn out, and then probably think about change the jobs after October if the company that you're already working has a labor and I-140 approval. And if the company that you're working doesn't have a labor and I-140 approval, definitely I will start working on having the company file a labor and I-140 approval so that when the priority date becomes current, you will be able to file the adjustment of status with them. But it's very hard to judge. Will it cross January 2015 date? Maybe. To what level it will go, it's going to be very hard for us to judge.
Sajid says my H1B is expiring September 2027. Can we do an amendment plus extension now due to a role change? And is that the same for the H4 and H4 EAD? Yeah, so even though you're not expiring until September 2027, you can't file an extension, a normal extension, until March 2027. You could file an amendment plus extension now. And if you do that, you can include an H4 and H4 EAD along with it.
A question is coming from Sri. His H1B is from Texas. He resides in Georgia. So I'm a bit confused. When your H1B is in Texas, what do you mean? Is your LCA has Texas address and Georgia address? If that is the case, if you move to a different address, if it is within 30 miles from where you are living, though, no LCA need to be filed, no amendment need to be filed. You're absolutely fine at all. Now, there are situations where we are noticing that remote working, when you remote work, though, you cannot change the location, guys. So let's say, for example, if your LCA is from, let's say, New Jersey, and you want to move to Dallas, though, even though you're remotely working in New Jersey, now you'll be remotely working from Dallas, though. You need to file an amendment before you make a move. We have seen mistakes time and time again. People get into trouble. And previously, these mistakes could have been rectified by getting the consular processing. You go to India, you get the stamping, and you come back, you're all safe. But that option is not available. Whenever a person's status gets violated on the H1B, that is going to incur a $100,000 penalty. The reason is that if the status violation is there, then they give a consular processing. Consular processing costs $100,000. So every mistake costs $100,000. So please Do not change your location until you check with your immigration lawyer to make sure you can change the location. Yes, if you're changing the location within 30 miles from where you're located at, that's perfectly all right. But if you're changing more than that, you definitely need to check with an immigration lawyer. And you need to make the amendment before you make the move. Oh, I'm going to go there, test myself, and then I will do it. No, the USCIS will find out, they will deny your application. Even if you are working with company A, you change the location from New Jersey to Texas, and you're now moving to company B, your company B H1B will be denied because you violated the LC of company A. There are times where USCIS is going back to even company X. That means even though you're working with company A, you're moving to company B, they are looking into company X, the previous company that you worked 4 years before, they are looking into it. So please do not change the location before checking with your immigration lawyer if you are an H1B.
Gaurav says, I had a law enforcement encounter. The case was dismissed. I'm transferring my H1B to a new employer. Received the first RFE for the biometrics, then got a second RFE asking for the court documents. How many more RFEs should I expect? Hopefully none. Usually with that second RFE, they've already looked at all the other issues in the case and confirmed that everything is ready to approve. They just need those court documents and the positive discretionary factors so that they can approve the extension of status that goes along with it.
Is it a good idea for EB5? I have my EB2 priority date as June 2015, or wait until October visa bulletin? Yike, that's a very tough question because we don't know if the priority date for EB5 will be current in October. At the same time, though, EB5 is not that easy, though, because it is more complicated. Even if you get the green card is only valid for 2 years. If all the conditions meet, then you're going to get a final green card. The total applying process to get the entire green card for EB5 may range anywhere between permanent green card is from 7 years to even 11 years, a minimum of 5 to 6 years. So definitely it may be worth for you to consult an immigration lawyer to evaluate which way to go it and then take a decision. It's not a clear answer, yes and no to you.
Satish Kumar says, if the priority date becomes current based on my previous employer's I-140, but my current employer has not filed a perm yet, can I still continue H-1B extensions using the previous employer's I-140? So once your final action date becomes current of the old employer's I-140, the next extension that you file is only going to be given for 1 year, not the 3 years that you've been given. But yes, you can use the old employer's I-140 approval to get that 1 year extension. However, if your final action date has been current for an entire year and you have still not filed the 485, and then you're trying to file an extension with the old employer's I-140, that approval is discretionary. USCIS could say, hey, you've had enough time. You've still not pursued the green card. Therefore, we're not going to keep extending your H-1B. So there is a cutoff. So you need to make sure if you are, if the April visa bulletin comes out and shows that your final action date is now current, you might want to hurry up and file an H-1B amendment plus extension in March to get a 3-year approval till 2029 to avoid getting a short 1-year approval later, just depending on when your current H-1B expires. Just you want to buy yourself as much time as possible to be able to make it through the perm process with the new employer.
My work location is 15 miles from my home. I work hybrid, sometimes in the office and sometimes in the home. Should both addresses be there on the LCA? I would keep it just for the convenience of the FDNS because that's easier when they come in, they want to inspect the things, they will have it. Is it legally required? Maybe, maybe not, but for the convenience sake, I will do it. Ajay Soni go ahead, Emily.
I was going to say, Ajay Kumar says, Heimlich filed a B2 while on the H-1B grace period, got the job, got the H-1B approved with the I-797A. B2 is still pending 3 months later. What do I do? So I'm assuming your H1B, when you say I-797A, that means the H1B was approved as a change of status. You have your new I-94. You need to withdraw the B2. Don't let it get approved. We've had a case where it did get approved, and then later, when the H4 spouse went to file for her H4 EAD, they said you're not the husband's not in H1B status because your B2 got approved after your H1B, and that B2 then expired already, and they were claiming he was unlawfully present. So be very careful about that. Once you have your H1B, you should withdraw.
Ajay Soni from Facebook has this question though. Is it mandatory for the company that I'm working to file an I-140, or is there any other pathway? He's asking this question in context of if the priority date if the priority date becomes current to file the adjustment of status. Definitely getting an I-140 with the current employer is the best and easiest way for you to get the green card. There's no doubt about it. Now, if not, the current company cannot file your 485 application. They cannot. Now, the previous company that has an I-140 could file it. Would they file it? We don't know. You can ask them. So definitely a lot of companies will say no because you're no longer working for our company. We're not going to file the 485 for you. There may be some companies that may say, yeah, even though you are not working for the company, we think so that you will come back and you once you get the green card, you can come and work for us. They can do it. But 95% of the companies don't do that. So for that reason, if the priority date becomes current, if your current company doesn't have a POM or I-140, you cannot file the 485 application, Ajay.
Robbie says H4 child's I-94 is expiring due to the old passport expiry. Now got a new passport. How do we extend the I-94? I've contacted CBP and I'm still waiting for the answer. Don't go to CBP. They won't help you because they only fix mistakes that they made at the port of entry. Getting a shortened I-94 when your passport is expiring is not a mistake in their mind. So showing them that you've gotten a new passport, they're not going to fix it. So your only options are to travel now that you have the new passport, assuming you have the visa stamp, go out and come back in, or if your visa stamp is expired, maybe potentially go to Mexico using automatic visa revalidation and come back in, assuming the child has an H4 approval notice, I-797 that's got the long I-94 on it. Otherwise, file the H4 extension early based on the shortened I-94, not based on the longer I-94.
John Rom from YouTube has this question. I previously was an F1, but stayed after series completion for about 3 to 4 months. Then I left United States, came back on H4, and the prior date is December 2015. Will it affect my green card process? Um, Multiple ways, no. One, the 245 case says that if the status violation is less than 6 months, you still are eligible for the 485 application, though, because this is in the employment based immigration. Second, as Emily has pointed out, the USCIS memo says that they should only look into the status violation from your last entry into United States to current, even though there was one or odd cases that were misinterpreted. So we don't see any problem in you getting the green card because of that status violation of 3 to 4 months that you did it on F1 and after which you came on H4 visa. We don't see any problem in you getting the green card along with your husband.
Robbie says, we filed H1 extension and premium along with the H4 and H4 EAD extension. Is it mandatory for USCIS to send an RFE for the ASC biometrics to take fingerprints and photographs? Yeah, so USCIS changed its policy in December. They no longer accept the photographs that you submit, and they make you go to a biometrics appointment so they can take your picture. So if your spouse has not gone to a biometrics appointment in the US within the last 3 years, yes, she will have to have a new photo done by the ASC center.
I got an interview request working for a big company. One speeding ticket in my life. Is that going to be an issue? Should I be very concerned because I got an interview? I would definitely have a mock interview done by an immigration lawyer. I'm not that much concerned for you, though. If you have the traffic ticket, you don't have to mention it on the 485 application unless it's more than $500 or it involves in an accident, which involves in some bodily injury. So otherwise, you don't have to mention the 485 application, though. So just because you got an interview should not by itself worry, because most of them are, they just randomly pick those things. There are some cases where people have issues. For example, if they have criminal issue. Now, traffic ticket for you is not a, it's not an issue for you. They should, there are many cases where we see there are no issues. They just randomly pick, they do the interview. That's very good. If your final action date is current, you should take that as an opportunity of buying a champagne bottle and keep in your refrigerator so that you can open it once you go for the interview and come back with a victory. So definitely, if the final action date is current, that's what I would do. I will buy a champagne before I go for the interview.
Nayak says, I'm on STEM OPT with about 1.5 years remaining. If I get selected in the H-1B lottery after October 1st, I would like to continue on STEM OPT and then change to H-1B. What options do I have in this case? You have to pay $100,000 to make that happen. So I hope that would be worth it to you. In other words, don't do that. You need to just file it as a change of status and switch over to H-1B. If you file your H-1B for consular processing, you have to pay the $100,000. If you file as a change of status and your change of status gets approved and takes effect on October 1st, you can't just go back to STEM OPT, it's gone.
King Devansh has this question. Would it be a problem for naturalization if you've never been employed after you've been greened? Assuming that if you are the main applicant, I definitely want you to consult an immigration lawyer, though. Now, if you are the dependent, though, on the green card application where your spouse is a primary applicant, then I don't see much of a problem there. But if you are the main person and then you never worked after you got the green card, I'm a bit concerned about it, especially in the new Trump administration.
BJ says, if I filed for H4 while I'm in my 60-day grace period, it's been pending for 5 months. If a new employer wants to file for H1B, what are the chances of getting an approval without consular processing? Well, prior to January 2026, I'd say no issues at all. That's pretty common. We would just include your H4 receipt notice, proof that you were maintaining your status at the time of the H4 filing, maybe even a copy of the H4 so that they can see that it's approvable, and then get the H1B approval. However, with this $100,000 fee in play, if you do file that H1B and they do send an RFE asking for the H4 approval and you don't get it in time to respond, the H1B is going to be converted to consular processing. $100,000 fee kicks in. So now everybody's just wasted a lot of time and money. So you may want to consider just waiting for the H4 approval and then filing the change of status back to H1B, to avoid a $100,000 mistake.
Had an issue with law enforcement. The case has been dismissed. No issues at all. I got an RFE for biometrics. I got the second RFE for court documents. How many more RFEs I'm expected? 99.9%, maximum of 2 RFEs. If it's a minor issue, though it should not be a problem, it is common right now. Since March of 2025, we are noticing the biometrics for the people who have any interaction with the law enforcement. And sometimes they just do the biometrics and approve it. Sometimes they issue an RFE after the biometrics. So second RFE, it's very common right now. And then ask for the court documents. And after that, they normally adjudicate the application. If it's something serious offense, though, definitely you should contact an immigration lawyer. But otherwise, it's normal for them to ask for biometrics and a second RFE for court documents. And after that, they do adjudicate their H1Bs.
Vinod Kumar says, 3 months ago, my H-1B was filed online. A week later, converted to premium processing and also filed the H4 and H4 EAD for spouse. H1 and H4 were approved, but not the H4 EAD. Is there a way to expedite? It's likely because of the biometrics policy where they need to take her picture for your spouse, and there is no way to expedite. I mean, you can call the 1-800 number and request an expedite. If your spouse is, in a job loss situation because of it or something like that, or severe financial consequences, but 99% of the time they are not expediting those. So your next best bet is to litigate, but you can't do that if it's only been pending for 3 months. It would likely not be successful.
I just want to let you know that if you want to speak with me, Emily, or anybody in our office, you can block a time that is suitable to you. Most probably, we would recommend try to do it after March 19th. That would be better because we're a little bit tied up on the things. If you can avoid until March 19th, that will be very good. And we do have a daily conference call, which is more interactive, where you can ask questions and you can join it. It's the link is provided to you at the bottom of it. We've been doing that from past 14 years. So you can come and join, and approximately 20-25 people will be answered there. There are a lot of people that come in there. And if you're a newcomer to the Zoom call, we do promote the newcomer. Anything else, Emily?
No, thanks for joining us.
Thank you very much.